Joining me now is Mary McCord, former acting assistant attorney general for national security. I have so many questions about this document. I just want to start with, we now know that they had the document, that Jack Smith's team had the document before the first indictment. So why was it not charged in the first indictment? Well, first time of the indictment, yeah.
Right. Well, it could be that they just weren't certain that that document that they had gotten back in the 15 boxes that Trump did provide to the archives in, I think, January or February. They could be they didn't have the proof that that's the one that he was showing to the two people, the autobiographers for Mark Meadows up at Bedminster. So this tells me, because they're very explicit in the superseding indictment, that that document is the document charged in count 32. That means they've got a witness, they've got somebody who can say that's the document.
So there are 31 other documents that have been listed. We don't know exactly what they all are, though they have levels of classification. Is your sense that that Jack Smith's team could go after other documents, or what would be the drawbacks to that?
So I don't think at this point they're looking probably to add more counts of mishandling. I mean, they have already a substantial number, and for each one of those, they have had to negotiate with the intelligence community the ability to use that document in court. In fact, that could have also been a reason for this document not being included in the original indictment. Could be that they hadn't finished those discussions with the equity holder. That would be the intelligence community agency who owned that information. And so if they add more counts of mishandling, which they could, there's lots and lots of documents, they'd have to have permission to use them. And then it would just extend out, potentially extend the trial date. Another superseding indictment, every time you add counts, every time you add defendants, there's the possibility that that will push the trial date.
That's interesting, and I'm sure a factor. There is audio that we knew about, and now they have the physical document. I've heard other legal experts say that now it means that that audio will definitely be used in court, and that before it was possible it could have been, that they could have tried to pull it out. Is that your understanding, and how significant is that?
So I think that even before count 32 was charged, I think there were very good legal arguments for the admissibility of the audio from when he was flashing it around up at Bedminster. That's what's called 404B evidence, in reference to Rule 404B of the Rules of Evidence, that allows information to come in not to prove sort of character or action in conformity with character, but to prove things like motive and intent and knowledge and absence of a mistake. But a judge can keep out Rule 404B evidence if the judge thinks that its probative value is outweighed by its prejudice. Well, here, when it is direct evidence of a count that is charged, direct evidence of count 32, there's really no argument that it shouldn't be admitted. So I do think this solidifies the introduction of that tape into evidence.
So tomorrow, Carlos de Oliveira is set to be arraigned. As we're waiting for that, what are you watching for, and what will we see?
So, I don't think it'll be a particularly noteworthy proceeding. I think the special counsel has already said there's no reason for Mr. Trump or Mr. Nauta to be there, so it will probably be just Mr. de Oliveira and his attorney. I expect he will enter a plea of not guilty, and that will be about it. They'll talk about conditions of release. I expect, because Mr. Nauta and Mr. Trump are not incarcerated, neither are detained pre-trial. I don't think neither will Mr. de Oliveira. I think they will impose the same conditions that are on Nauta, which is that, remember, Nauta and Trump are allowed to talk to each other about work, and I think the same will apply to Mr. de Oliveira, but they're not allowed to talk to each other about the charges or the facts of the case. And that's the thing that's tough to police.